Welcome to Guardianship and Guardian Advocate and the Basics post Regis Little. We're going to have 3 speakers for you today, and we also have a guest speaker from Disability Rights Florida. My name is Sharon Langer. I'm from Disability Independence Group, a nonprofit law firm that represents persons with disabilities. We're also going to have Wendy Robbins Cleary, who is a supervising attorney and the director of the Guardianship Department of Dade Legal Aid, and Deborah Schroth from Department of Children and Families. The way we're going to structure our training today is we're all going to be speaking to you about these 3 different topics. We're going to pass out right now index cards. So if you have any questions, write them down. And we're going to reserve quite a bit of time at the end for questions, for comments, for conversation. So rather than take questions while we're speaking, please write them down, and we will promise you that we will get to them when we get to the end. So without further ado, I'm going to turn the program over to Deborah Schroth. Deborah.
Thank you. Thank you. Good afternoon, everybody. And I hope you can stay warm. I am chilly. So, you heard this morning a little bit of the story of Regis Little, and we are talking about how to implement the Regis Little Act. So who was he? Well, he started out as a normal child. He lived with his mother. His dad had nothing to do with him. So when he was 4, his mom died. And from then on, his life was hell. He was shuffled between an elderly aunt and uncle, half-sister, group homes, etc. He never made it to kindergarten. So at some point in his life, he was kept in an isolation cell. He was placed on at least 5 psychotropic meds, and by his junior year in high school, which he never finished, he was still illiterate. By the time he turned 18, he'd been molested, he'd been arrested, he'd been multiple times shuffled between group homes, family, locked facilities. He hated being alone and in the dark, and he had an IQ of 65. He had diagnoses of bipolar, hyperactivity disorder, and aggression. When he left the system, he left with nothing other than a disability check of $1,000 a month. He was left to fend for himself with no one and nothing to assist him. At that time, we did not have extended foster care. And at 18 years and 11 months, he was dead. And as you heard, he died of murder. This is his older sister. And here we have the law. So, unfortunately, Regis Little is not an anomaly in our system. We have children who are like him, and that's why we have this guardianship law. So, how do we identify these children? And after we figure out how to identify them, then we will talk about how we actually secure guardians and guardian advocates for our children. And then how do we find the guardians as well? We will be talking about all of these things. So we wanted to say, well, first of all, aside from what's in this presentation, to me, the work that we should do to identify those children who need guardians and guardian advocacy should not be a separate task. It should be part and parcel of the transition planning process. We should apply the techniques that we use to all of our children across the board, because all of our children, as they age out of our system, need some kind of assistance. If they didn't need any assistance, they wouldn't be in our care. But they do need something, and so that's what our transition plan is all about, to make sure that the child and we know what the child needs as they become an adult, who's going to provide it, how it's going to be provided, when it's going to be provided. I hope that in your practice, you all look really hard at these transition plans, that you attend the transition planning conferences, and you make sure that the children attend them as well at a date and time and place that's convenient for them. So we're going to sit down and look at a transition plan process. We have to know what we're doing at the 17-year-old judicial review hearing in any event. So that's a great time to begin this. So which of our kids do we think are the ones who need enough help that it becomes a guardianship or guardian advocacy? Well, if we have a child with a diagnosis of a developmental disability, whether or not they're receiving services from APD, simply if they have the diagnosis, we should be careful to be sure we plan for their future. If they're receiving SSI, that means that the child has a disability. That's different if the child is receiving other benefits through the Social Security Administration. They may have disabilities, but if a child is receiving SSI, that child does have a disability. If the child is receiving APD services or is on the wait list, again, in order to get APD services, you have to have a diagnosis of developmental disability. If a child is receiving Children's Medical Services level Medicaid or in a medical foster care placement for a serious medical condition that impairs functioning, that's another child that we would be considering for guardianship purposes. And if a psychological assessment indicates that a child has a lower IQ score. That's not all of the kids who may need a guardian at some point. We also have kids that have traumatic brain injuries. That is not a developmental disability, even though it may result in the same kind of issue, but a traumatic brain injury is something that happens to you after you're born. A developmental disability is something that you are born with, and that's the difference between them. They have the same results, so keep those kids in mind too. If we have a child who's in a coma for some reason as they're turning 18, that person is clearly going to need a guardian because that child, now an adult, can't make decisions for themselves because they're in a coma, for example. So what we need to do is be sure that we identify these kids as early as possible. Have any of you worked on finding a guardian or guardian advocate for any of our kids? A small number of you. It's pretty hard, isn't it? Yeah. It's all fine, well, and good to have this law, but finding an actual guardian is a real difficult process. It's something that case management ought to be working on, and if we can help them work on it sooner than later, so much the better. So we need to start the conversation about the youth's needs early on. So when we do it, we should look at file review and research. What are the youth's disabilities? What help is this child going to need to ameliorate the effects of their disability? But at the same time, we're looking for the least restrictive help that meets the youth's needs. We are not here to advocate for all children with disabilities to have guardians. That is the last thing in the world that any of us here would advocate for, because we also want our kids to retain as much independence as possible. So we urge you to look at our youth as being on a scale. So some of our kids are going to need, very few of our kids, but some of our kids, when they age out, are going to be similarly situated to their peers not in foster care. Not very many, but we may have some. Some of our kids are on track to graduate from high school. They're on track to either go to college or go into some sort of job training program. They don't need any greater assistance other than what's already available to them through extended foster care or PES. We have the other children on the other side who very clearly need a guardianship. The child with the TBI, the traumatic brain injury that is no longer able to have executive functioning. The child who has a developmental age of 6 or 7 or 8 years old. There are some kids who clearly need guardians, and we need to marshal the evidence to show that, but we have it all. It's not an issue. But then there's a whole group of our kids in the middle of this. They're somewhere in that range. And so what we need to do is to identify what their needs are and what help they need to meet those needs. It's not to say, oh, you're in the middle, so we're going to automatically look for a guardian for you. No, we don't need to be taking away people's rights to vote and rights to marry and all. I mean, they have every right to function as adults like the rest of us. It's our obligation to figure out how to provide community services. We need to try to figure out which of the kids really, really need that overall help of a guardian or guardian advocate. But then on the other hand, I'm going to tell you that if you have done all of this research of looking, talking to the doctors, talking to the service providers, talking to the youth themselves, and you're not sure, you think the child's on the cusp of needing a guardian, in my mind, it's better to then go and pursue guardianship, because you're going to go to the court, the dependency court first, and then somebody ultimately will go to probate court. So we're not the final judge of the matter. The judge is the judge. So what does the Regis Little Act require? Well, before the 17-year-old judicial review hearing, it requires an updated case plan with a face-to-face conference with the youth if appropriate, and all other relevant persons. Sometimes it's easy to schedule these conferences for the convenience of the primary stakeholders, the case manager, perhaps one or two other service providers. But we shouldn't be doing that for any of our kids, whether they're 17 or younger. We should be scheduling these case plan conferences and all other conferences with the kid at a time that's convenient for the child, with enough advance notice so that the child can either invite him or herself or ask us to invite for her the people that the child wants at the table. We need to have enough advance notice so that the teachers and the service providers that we're going to invite have the time to plan to get there. We shouldn't say, oh, it's Thursday afternoon, tomorrow afternoon we're going to do this. Can you come? Most people are going to go, heck no, my Friday afternoon's already scheduled. I can't come tomorrow. Maybe I can come 2 Fridays from now, but not tomorrow. So please try to make sure that we keep the kids in mind. I know that at some point in this conference, there's going to be a presentation on nothing about us without us. Keep that in mind for this type of work as well. So at the 17-year-old judicial review hearing, if you think that this child does need a guardian or guardian advocate, then that should be raised with the judge. I am aware that the JRSSR, the Judicial Review Social Study Report, the templates for it has no place right now to say anything about this, but it should go in the JRSSR in any event. Technically, I don't know whether you have to add a separate addendum page, how that works with FSFN, but in any event, there should be something that says something about it so the judge knows whether that's going to be part of the judicial review hearing or not. If you have a child with a disability, but you believe that other services in the community, the lesser restrictive alternative, will work, put that in the JRSSR and be prepared to talk about that at the judicial review hearing. So at that point, at that hearing, the judge is supposed to make a determination if he or she believes it to be true that there is a good faith reason to believe that this child will require a guardianship. And that then sets all of our guardianship finding and all of that work in motion. On the other hand, if we are able to show the judge that this child needs additional help, but here's the community services that are available, then the judge can order that to happen. And that will go into the transition plan, and that will be what we do. So the next thing, if the judge says this kid is going to need a guardian, then we have to complete a multidisciplinary evaluation if one has not been done in the last 2 years. And that evaluation should include a psychosocial eval with a full-scale IQ and an educational report. So we have to get in touch with the teachers. And then the department, DCF, is the one that's tasked with identifying one or more individuals who are willing to serve as the guardian. So this Regis Little statute allows for the guardianship to be filed for kids in foster care at the age of 17 and a half. That's to avoid a gap. We don't want to have a situation, if we can avoid it, of a child who requires a legal guardian, but we don't get around to filing the guardianship until they're already an adult, because who's going to make decisions for that young adult who can't make decisions on their own until you get the guardianship order? We don't want to have that hiatus. And let me also mention that if a child, a young adult now is going to be living in an APD home, that does not take the place of a guardianship. If that young adult needs a guardian, you still need to get a guardian even though they're living in an APD placement. Because APD is a home, it's a placement. Nobody has legal custody over that person. So please remember that an APD home for a young adult doesn't answer the question. So what is a guardianship? Well, I'm not going to answer that. Someone else, Wendy, is.
I think I'm going to go up and have the podium look really good in front of me, so I can yell. And this mic is a lot more sensitive. So, what is a guardianship? It's a legal proceeding where a guardian is appointed to exercise the legal rights of the person who has been deemed incapacitated. We're not the experts. We're the legal experts, but we're not the experts. You have the most knowledge about these youth. So are they incapacitated? You have to look at Chapter 744. An incapacitated person means a person who has been judicially determined to lack the capacity to manage at least some of his or her property, or to meet at least some of the essential health and safety requirements of the person. Well, what is that? It means to take those actions necessary to provide the health care, food, shelter, clothing, personal hygiene, or other care without such serious and imminent physical injury or illness is more likely than not to occur. Renting an apartment, going to the doctor on their own, making those medical decisions for themselves, making money and those types of decisions. You all know them better. To manage property means to take the actions to obtain, administer, and dispose of real and personal property, intangible property, business property, benefits, and income. Social Security disability benefits, other types of income. Well, how do you know? How do you know if a youth is incapacitated per the definition? Only a judge can make that decision. Deborah told us that very succinctly. But bring all youth that appear to lack the capacity to manage at least some of the property or meet at least some of the essential health and safety requirements of the person to the dependency judge. Ultimately, though, it is the probate judge who will make the finding of incapacitation. But that doesn't mean that they won't take into consideration what the dependency court has found in the best interest of the child. So, how do you get a legal guardianship? Hopefully in your, thank you. Hopefully in your jurisdiction, you have a system set up. It may not be. Hopefully that's trickling down, and each jurisdiction and each circuit is getting better at addressing these issues. But a detailed petition is going to have to be filed in the Circuit Court of Florida alleging that a person is incapacitated. A lot of jurisdictions want the petition for incapacitation to be filed at the same time a petition for guardian, to appoint a guardian, is at the same time, or within the same document. Dade County, they like it to be separate, but within a couple of days of each other. Any competent adult can file a petition to determine others' capacity. Certain persons are excluded, and I know that's a huge issue, and I'm going to get to it. And it must be filed in the county where the alleged incapacitated person resides. And the alleged incapacitated person is what the youth is called before such time that they are declared incapacitated, and then they are called a ward. So after a petition is filed, the petition to declare incapacity, then the court appoints an examining committee. There's 3 doctors, usually a mental health doctor, a PhD, and another physician, a mental health. There's going to be a facility type of evaluation, functional assessment, I'm sorry. And then an attorney is appointed for the alleged incapacitated person. It's usually regional counsel. We'll get into other attorneys later. The members of the examining committee and his or her attorney visit the AIP That's why in your petition, contact information is key. If he's in an APD home number, contact person there. If he's not in an APD, or he or she is not in an APD home, then wherever they are, that contact information is key. And they must submit their findings to the court at least 5 days prior to the hearing. Usually, I put out some feelers around the state. I know for the southern part of the state, it's within 45 days of filing is when you're going to get a hearing date. And for the most part in Miami, we get those reports the day before. So that's not unusual. The court-appointed counsel will also visit the AIP to inform them of the proceeding, receive their direction if the youth is able to express it. Prior to a hearing, the judge is going to review everything and review the examining committee reports, and at the hearing is going to listen to arguments of counsel for the petitioner and counsel for the youth. The hearing is considered an adversarial proceeding because you're taking away all the rights of the youth, or some. If the committee finds that the youth is not incapacitated, then the petition will be dismissed. Judges usually follow the majority of the examining committee. So if you have one full incapacitation and one limited, they're going to go with the full. If the judge finds that the youth can exercise some, but not all of his rights, and I'm going to show you what those rights are, then it's called a limited guardianship. I see a lot where they are allowed to vote. They can be in charge of their own social environment. If the person can exercise no rights, then it's called a plenary guardianship, a full guardianship. And at the end of that incapacitation hearing is when a guardian is appointed. These are all of the rights that are listed in the statute. Marry, vote, apply for your own benefits, have a driver's license, and drive. Travel, seek or retain employment, sue or be sued, to contract, manage property, or to make any gift or disposition of property, and consent to medical treatment, and make decisions about your social environment or other social aspects of life. There are a lot of things that we take for granted, but they're huge. If all of those rights are taken away, it's plenary. But according to the statute, the plenary guardianship must be the least restrictive appropriate alternative. Those are the huge buzzwords, least restrictive alternative. A limited guardianship is when certain rights are delegated to the guardian, but the youth retains the rest. Now, who can be a guardian, or what? Well, an individual, an institution such as a professional or the public guardian, who's been appointed by the court to care for the youth and or their assets by exercising those rights specifically delegated to them. Any adult resident of Florida can be a guardian. A non-resident of Florida can be a guardian if they are related by lineal consanguinity to the ward, or a legally adopted child or adopted parent of the ward, or a spouse, a brother, uncle, aunt, niece, or nephew of the ward, or someone related by lineal consanguinity to such person, or the spouse of the person otherwise qualified under this section. So it's a lot of people, if we can find them. Biological and or adoptive family members, including biological parents, if their rights were not terminated, and adoptive parents under certain circumstances. Now, in the Chapter 39, 7013B2B, a written order by the dependency court finding that such appointment is in the child's best interest for a relative to be the guardian. Nonprofit agencies, there's also the public guardian, and there's professional guardians who cannot be the guardian. And by the way, there's a huge website throughout the state of Florida for professional guardians. And a lot of those professional guardians will sometimes take pro bono. You just have to reach out and ask. Okay, so who, beg, please. So who cannot, yes. And I do, I beg. I am not ashamed to say that. And I've been successful with that begging. So, who cannot be a guardian? Persons convicted of a felony. And wait, let me grab my, it doesn't matter. Persons who are incapable of carrying out guardian duties. It could be because of a physical ailment they have or a psychological ailment. Maybe they have some mental issues. You have to identify those. Persons who have been judicially determined to have committed abuse, abandonment, or neglect against a child as defined in 3901 or 98403, 1, 2, and 37. I'm sure you all are familiar with that. Or the child's attorney cannot be the guardian. Now, this 43504, I wanted to, wait, oh, sorry, it just went, phew. Okay. In addition, persons who have been found guilty of, regardless of adjudication, or entered a plea of nolo contendere or guilty to any offense prohibited under this other statute, 43504, or any similar statute of another jurisdiction, anyone with a conflict of interest like an ALF owner, an APD home owner, or the child's attorney. Now, what is 43504? Because I would be interested and I would want to know if I was here listening. It lists over 52 different crimes, most of which the crimes are against children, the disabled, or the aged. There's a lot of sexual crimes listed in there: murder, manslaughter, assault, battery, vehicular homicide, arson, firearms, a lot of weapon crimes. So I just wanted you all to be aware of it. So what do the guardians do? They exercise the rights that have been removed from the youth and delegated to them. This may include determining where they live, managing their finances, making their medical decisions, and they must visit the ward at least once personally each calendar quarter. Are they accountable? This is where it gets tricky, because a lot of lay people, a lot of lay guardians would love, guardian litums would love to be the guardian, but then they realize this comes in, it's a little sticky. Yes, a guardian is accountable, but they are represented by an attorney who serves as the attorney of record throughout the entire guardianship, which is the life of the youth. They're usually required to furnish a bond, maybe required to complete a court-approved training program, but it's usually waived for the public guardians, and it's usually waived for like legal aid clients. I represent, right now, we have over 918 open guardianship cases at Legal Aid of Dade County, so we are the attorney for all of those guardians. And we have about 12 to 15, Kristen, correct me if I'm wrong, 12 to 15 right now, ongoing foster youth guardianships. So, but if a guardian does not carry out their responsibilities, they can be removed or even charged with a crime, exploitation. How long does that guardianship last? This is the other problem, not for the youth, but for us trying to find someone. It depends. If a person recovers, or if a youth recovers in whole or in part from the condition that caused them to be incapacitated, like if they had a traumatic brain injury, or if they were in an accident or in a coma, they come out of the coma, well, and they have capacity, well, then that guardianship can be over. They may be re-examined and may have all or some of their rights restored. Many, though, are the life of the ward. Any interested person, including the ward themselves, can file a petition for restoration. It involves a re-examination by a court-appointed doctor. It's only one doctor. When you get incapacitated, there's 3. When you want to be restored, it's 1. It's easier to be restored than it is to be declared incapacitated. If a guardian has been appointed and the youth remains in care, then at each subsequent JR, the court shall review at the permanency review hearing the necessity of continuing that guardianship, but that's really only until they reach 22, and then once jurisdiction ceases, then it's up to the guardian and the ward to actually have these conversations yearly, according to 744. A guardianship can also be terminated if the guardian fails to carry out their duties or becomes ineligible. Perhaps they pass away, they become incapacitated, or they're deported, which is very ripe right now. And also, their duties are an annual report every year about how the ward is doing, where the ward is, what are their needs, and a doctor's report. If they fail to do that, then they can be removed. A successor guardian must be identified and appointed as soon as possible. For the most part, it's usually the public guardian that comes in after someone else can no longer do it. A guardian can be discharged if they're unable to continue to serve, or the ward is totally restored. And of course, if the ward or the youth die, then the guardian is dissolved. So what do you need? You need proof of their identity, their birth certificate, if you can get it. There needs to be a little file that's started with everything that they're going to need to file for guardianship and to pass along to the guardian, so the guardian has all of this information in order to care for them. Their identification, social security card, birth certificate, immigration card or naturalization papers, if applicable. Their Medicaid card, proof of Medicaid eligibility. And there's that multidisciplinary psychosocial evaluation, which includes complete with diagnoses, full-scale IQ. The full-scale IQ is super important because if you have an IQ, you can identify further services. If it's below a certain amount, APD will come into play. But that is super, super, super important. And not an abbreviated. I see a lot of the abbreviated IQs or abbreviated evaluations. No, we have in the app, we submitted some papers, and Deborah Schroth was so kind enough to give you some language to put in your orders so that you have that language for the orders for the evaluations. We need any and all final orders from dependency or juvenile court, not the shelter order. Shelter order is a great start. We kind of need something that lets this court, the probate court, know, okay, what's the status of the dependency action. And also, it tells the dependency court whether or not, along with an order from the dependency court saying what's in the best interest of the child as far as family members, but what family members were terminated, what was mom terminated, was dad terminated, do we have a finding of dependency? We need that. Death certificates, we need information on the siblings and the relatives of the youth, because in probate, every relative has to be notified. Information pertaining to assets, a current and last year's SSI letter saying what the benefits are but from Social Security, not from the trust. What you can do, consider if the youth would benefit, recommend guardianship, review that recommendation annually, and have them evaluated once a year to see if they have improved or not. Review what documents are needed. Make sure everything is in order to be filed when they turn 18. There is a gap between filing the petition and having a guardian appointed. Like I said, it's about, in Miami and Palm Beach at least, which I've been able to identify, 40 to 45 days from the filing of the petition to a hearing date. So, at least in my jurisdiction, which is Dade, we've been authorized to file these 60 to 90 days out. The problem with filing them 6 months out is that you need to have that hearing as close as possible to the 18th birthday. And make sure the youth has appropriate housing and assistance at 18. And I will tell you this, we did not put emergency temporary guardianships in here, but I will give you a little insight into ETGs, is what they call them, is that the court will will deny an ETG just because there's a guardianship not in place at 18, because there's no imminent threat of harm. So just remember that you can't just go in and get an ETG at 18 because the hearing for the probate case is not until, the probate guardianship is not until 5 days after or 10 days after their birthday. So it might be a good thing to also reach out to your local probate court and become friends with them. Perhaps you can call the attorneys who are doing these guardianships, can call the court and ask, can we have this hearing put up maybe 10 days so it coincides with the birthday? I have a feeling that they'll all oblige you. And remember that the decision for the guardianship is made by the probate court. Okay, and now I'm going to pass it on over to Sharon, who's going to talk about a less restrictive alternative.
What do you push? What do you push? All right, I'm going to try this. I've never done this before.
This one.
All right. There is an alternative. We started out with the most restrictive, although Deborah mentioned, and we all three agree, that it's very important to look, and we don't do it as much as we should, in my personal opinion, is look for the least restrictive means of creating a safe and meaningful life for the youth that we care so much about, which is why we're here today. And the alternative to Chapter 744 is something called Chapter 373.12, and it's guardian advocate. We call it guardian advocacy, but the person that's going to serve in that role is the guardian advocate. I can only speak to Dade's experience, and I will tell you that we rarely have done these for youth in foster care. It just was not on our radar. So some communities have done a better job. If you're in one of those communities, I applaud you. If not, I suggest that you seriously look at this alternative. Unlike the full guardianship, a court does not have to declare a person that has got a developmental disability incapacitated, and that label can mean a lot. So while in the 744 full guardianship, you have a legal declaration by a court that somebody is incapacitated, you don't have that at all under 373. Instead, the focus is completely the opposite. The focus is on decision-making ability of the individual. So rather than looking at what you can't do, the reverse is you look at what can be done. And the individual, we don't really call them a ward, but the individual, the former foster youth, retains all the rights that everybody has except those that are delegated to the guardian advocate. So it's a really different mindset and a different way to view this type of support that we're giving the youth. There are annual reporting requirements. They're very limited compared to what Wendy didn't really talk too much about them, but there are requirements, significant requirements under 744. They're very limited under 373. And in some cases, it's not even necessary to retain an attorney. You absolutely, by law, do not have to have an attorney of record for a guardian advocacy, which is a very big bonus. Because as we're going to talk a little later, it's sometimes very difficult to identify an attorney that'll stick with a case for perhaps, could be 50 or 60 years. Let's see if I can make this turn. Now, a guardian advocate still has to meet, the guardian advocate himself still has to meet the 744 requirements. All the things that Wendy told you about with felonies and prior criminal acts, all of those things will still apply to whoever's applying to be a guardian advocate. But it's the only bit that's a little bit difficult for a guardian advocacy is the following. There are only certain categories of disability that qualify, and I'm going to tell you what they are. And it's by statute, and there's no getting around it, but they're pretty broad. You have to have either a diagnosis of mental retardation. Some of these words are kind of out of fashion, but I'm reading you the statute. Cerebral palsy is number 2. Autism, and they just use the word autism, so my suggestion is the entire spectrum would qualify. Spina bifida, Down syndrome, or Prader-Willi syndrome. And those are the only categories. They're kind of broad, but those are the only, we'll get questions at the end. Those are.
I wanted to point out something you just said.
Yes, ma'am.
The entire spectrum, that does not, it's the extreme end of the spectrum for autism with APD.
Is that by case law? Because that's not what the statute says.
It's by APD eligibility standard.
All right, well, I would appreciate it if we could talk about that. I'm just reading you the statute, and the words in the statute say autism, but I appreciate it. Let's talk some more when we get to the break, to the talking time, question and answers. Thank you. Part 2, those are the categories of persons that qualify. They must this condition must be manifested before the age of 18. And the third point is, it must constitute a substantial handicap that can be expected to continue for the rest of the person's life. So you can see where that narrows some of the other things that Wendy told you under 744. And I just wanted to talk a little bit about what they mean by intellectual disability. Under 37306324, they kind of give you some more information, and they say means significantly sub-average general intellectual functioning existing concurrently with deficits in adaptive behavior, which manifests before the age 18, as I just said, and can reasonably be expected to continue indefinitely. They talk about adaptive behavior. In the statute, it says means the effectiveness or degree with which an individual meets the standards of personal independence and social responsibility expected of his or her age, cultural group, or community. So that kind of, the statute gives you a kind of a flavor for what they're talking about. Now, we are going to pass out the chart that's on the screen. There's no way I know that you can read that. And so we made some copies. If we don't have enough to go around, our emails are in the program that's listed on the app, our PowerPoint. Reach out to us, we'll be glad to provide it. This is a nifty chart that compares for you guardian advocacy and guardianship. And we're just giving you the flavor for it, but this is going to give you something you can take home that actually will chart for you the differences. But I want to go over just a few of the highlights. One of the things that's similar is that you can apply for a guardian advocate of the person, the property, or both, just like in Chapter 744. So you can be even less restrictive. You don't have to be a guardian advocacy over everything. It can be just the person, just the property, or both. A guardian advocate of the person, is one example, can seek to make personal decisions, including determining residence, consenting to medical or mental health treatment, or making social decisions. So similar to the same things under Chapter 744. But it gives you a flavor for the kinds of things a guardian advocate of the person would look to be able to do. If you were a guardian advocate over the property, you could ask the court to allow you to make decisions like contracting, suing or defending lawsuits, managing property, or managing financial gifts. If you're going to be a guardian advocate and somebody has no assets other than their Social Security check or the SSDI check, then you can become the representative payee and take care of that. Generally, the court does not require any bond, and it does not, as I said before, require an attorney of record unless there are significant assets. And we've had youth that perhaps had a family member that passed away. They do have money. They do have an estate, so to speak. If, in fact, you're a guardian advocacy and there is property or money, the court possibly could require that there is an attorney of record in that case because of the monies that were involved. But it's not commonly anything you're going to see for a former foster youth. The powers of the guardian advocate are not different than the powers of a 744 guardian, but they are only the powers that the court gives you in the court order. So you're going to get an order as the guardian advocate. You're going to get an order. It's going to list the rights that you have to exercise as the guardian advocate. And anything that's not listed there is a right retained by the youth. So once you become a guardian advocate, you still have responsibilities, even though it's generally a one-time hearing in court, in probate court. And you generally don't have to go back every year. You don't have to file annual reports unless there is some significant assets. You still have responsibilities, and I wanted to tell you briefly what they are. Even if you're the parent of a person with a developmental disability, a guardian advocate, you're a parent, most of these cases it won't be parents, it might be a guardian ad litem who's willing to take on this role. You do take on fiduciary duties and you do have some oversight by the court. Again, your rights are only limited, your rights are only the ones the court gives you. You don't have rights if you're not specifically elicited in the court order. If you find with time that you need greater rights, you thought, okay, perhaps I don't need guardian advocacy over the person. We can just take care of it with the property. And later on, you see, maybe I need to handle some of that as well. You can go back to court under the same case number and ask the court, of course, there would have to be an evidentiary hearing to extend some of those rights. Within 4 months of the appointment, with the appointment being the day of the order, you may need to complete a court-ordered guardianship education course. That's the same thing you have to do with Chapter 744. We didn't mention it, but there's a mandatory course. It's offered online. Occasionally, if it's a very limited guardian advocacy, you can ask the judge to waive that course. And you must file an initial report within 60 days of the appointment, the day you got your court order, and it will set out the mental health, medical, social, personal care needs of the person and how they are going to be met. So you got to have a plan, and you have to present that plan and file it with the court. And then a similar report needs to be filed with the court annually within 90 days from the anniversary of the date of appointment. So you don't have to do a formal annual report, but you do have to file sort of an update on the things that I just mentioned. If you're the guardian advocacy over property and there are assets, the court may require some additional reporting. You do not need an attorney, and that's one of the most significant differences, and we're going to talk a little bit more about that. Finding an attorney of record for a 744 guardianship is sometimes a challenge. And generally, the guardian advocate becomes the payee. Almost every circuit has their forms for guardian advocacy online. And since a lot of folks are willing to do this and they don't have an attorney, even though as an attorney I recommend at least helping file the initial petition, it's helpful to have an attorney. Go to your circuit. Most of the circuits have forms online that will tell you exactly what to do. I wrote in here, are there benefits to having an attorney, and have paragraph after paragraph for you why there are, but I don't think I need to say it again, but I think if you're building a system in your circuit where you're going to propose guardian advocates and guardian advocacies for some of your youth, that it would be a good idea to put together a panel of a few pro bonos, at least to help somebody gather the information and prepare for their presentation in court. It's not such a big deal to ask an attorney to appear once at a probate guardian advocacy hearing. It's a lot different than asking them to be attorney of record in a case for a very long time. Let's see if I can move to the next slide. There are less restrictive alternatives to even a guardian advocacy, and Amanda Haystack's going to come up in a second and give you a bit of an overview. She's with Disability Rights Florida, and I think it's really important. We never included that piece when we've trained before, and I think it's important to give you the whole spectrum of things that you can do. We feel, at least from our experience in Dade, and we've talked with Deborah about statewide experience, that honestly, it's a big challenge to find folks that are willing to serve in the role as a guardian, and it's a challenge to find folks really willing to serve the role as a guardian advocacy. They have to go through criminal background checks, there's conflicts of interest.
Sharon?
Time?
No, I was just going to add something. For the guardian advocate, there is nothing that says that lay guardian ad litems can't be a guardian advocate. So please explore that pool. You have fabulous people who are volunteers as guardian ad litems, and they can be appointed as a guardian advocate for the youth, maybe over their money, maybe over the medical stuff, but please explore that.
Right, I tell you that I get calls all the time now from different circuits around the state, and they'll have a guardian call me, a guardian ad litem, and say, talk me through it. And I usually send them the chart, they get a flavor for it, so we're more than willing to serve in that role until you establish in your own circuits whatever resources you need to make sure all these things, if they need to happen, can happen.
And the one other thing that you mentioned was online, you can find the guardian advocate forms. There's a plethora of instructional manuals plus forms, just Google it, because it's the same throughout the state. It's in the statute, so it's the same throughout the state, but there's certain circuits that have been so generous in posting huge instructional packets plus forms. So just so you know, you can go in there and just educate yourself about what needs to be done.
We found it a challenge in Dade to find pro bono attorneys. Fortunately, Dade Legal Aid has been willing to take these cases. Some of your legal aids will, and I suggest that you reach out to them. Some of them do not have the resources to become attorney of record for that, sometimes 60 or 70 years on a case. But we feel very strongly that Regis Little is almost 2 years old. We are all mandated and charged with making sure that youth do not exit our system without the supports that they need to have a meaningful and successful life. And so we need to each work within our own communities to develop pro bono panels if necessary, to work with our local legal aids and legal services corporation agencies, and create this group around this issue. Otherwise, what happens is time passes, we're not meeting our statutory requirements under Regis Little, which are very, very concrete and very specific. And we're offering to you, if any of you are interested, to discuss our experiences with creating pro bono panels, working with your public guardian if important, if that's the best way to go in your community, and working with your private bar and your private bar associations to make sure that this safety net of legal surrounds your youth. And with that, I want to welcome Amanda to come up.
If I may, you all, if you have any questions and you've written them on those cards, please just pass them over, and then Kristen Foyer from our attorney with our office is going to pick them up and bring them up. And also, I just wanted to mention really quick before I forget, I know that public guardians is always a type of an issue, and maybe they won't take them, maybe they will take them, but I will tell you that Dade County was successful. Some people may say, well, it's not really that successful, but I think it is. It's a little win. And we have a pilot project with a public guardian, and it's a number of kids that can go in there. And frankly, if it's referred to me to do the legal work, then I wrap up that referral with a little bow so that there's no way that they can say no, because I know that there are some public guardians that say no. But please reach out to your public guardian. I will send you the pilot project that was from Dade County, and you can maybe approach your own public guardian to see if they will do the same type of thing with your local CLS. And I know that we were short some of that chart. Please email any one of us, and we will send it to you. So I apologize for being a little bit short. We weren't quite sure of our numbers. So now, turn the little house.
So, my name is Amanda Haystack, and I'm a legal director at Disability Rights Florida, and we're the protection advocacy system for the state of Florida. And that does include children with disabilities as well. And Sharon asked me to briefly speak about a case that I had. I was in the earlier address in the welcome where Alan was talking about it's the stories that we tell, right? So there's a client of mine that I had recently where he fits into this gray area that Sharon kind of described. He was a foster youth, came into the system as a teenager. So he had a father, but he moved in the foster care system. As he aged out, he was put into a guardianship. And they started with a limited guardianship just over finances, which was appropriate. And he turned 19 and then 20, and he, like most 19, 20-year-olds, he did some things that were probably inappropriate. Never got arrested or anything like that, and that's nothing terrible like that. But, you know, he stayed out past curfew. He was living in a group home. He is also on the APD waiver as well. So he has a developmental disability. And so after he kind of acted out or what have you, they moved for a plenary guardianship, and they put him into a plenary guardianship. And because so many people were worried about him, and he was acting out, they actually moved him to what they call a behavioral group home. Are you all familiar with those? Okay, a lot of nodding of the head, all right, so I don't have to explain a lot of this stuff. So they moved him to a behavioral group home where he was quite honestly mistaken most often as staff. He's high functioning. He didn't have the problems that his roommates had. He eventually started, they had him doing things. Yes, you have to clean your house when you live in a group home, but you shouldn't have to clean up your roommates. And he eventually was used to do that. He would take mattresses out into the yard and clean them. So he got fed up with the situation, and he actually reached out to multiple people. He called Family Care Council of Florida. They're the parental group for kids with disabilities, people with disabilities in the state of Florida. And then he eventually called us. And when he called us and I got on the phone with him and I talked to him, I said, oh my God, why are you in a guardianship? This is a kid who, prior to going into the guardianship, he completed the Sheriff's Explorers program. He was acting in a play with his local theater. He went to church every Sunday, was active in their youth group. He was involved with guardian angels. He did all sorts of stuff. This kid was out and about in the community, and quite honestly, that's probably what got him into the guardianship, was that he was so out into the community. Nobody felt that they could keep tabs on him because he would come home past curfew. And so they moved into this plenary guardianship mode. The backstory to that is, so you don't think that he's just like every other youth or what have you. There are some things that I just kind of wanted to put out there as a thought in your head, why do they need a guardianship? Because sometimes they're not getting what they need. And in his case, he was grieving the loss of his father and his mother. No one got him grief counseling. No one got him any courses to learn financial skills or anything like that. So he had a couple of bounce checks and he overdrafted his account and stuff like that. So he did like routine things, like I will tell you, I did that when I was 19 and 20, overdrafted my account a few times. But he didn't have any parents to take care of him or do that. So in a way, the guardianship, I understand why they did it and they kind of moved in the right direction, but at one point, it far exceeded what he needed. So when he contacted us, I talked to him about restoration of rights. He said he was interested. I said, all right, let's do this. So we filed a petition. We get a doctor on board, and the doctor evaluates him and says, okay, he should be restored as to all of these rights with the exception of 3. And the 3 were to manage his finances, to contract, and to sue and be sued. And mind you, I got to go back because his right to vote was also removed. And for the life of me, I cannot figure out why his right to vote was removed. Yeah, he made poor choices, but so do a lot of people voting these days. So he should be able to vote, right? So with those 3 things, we were like, okay, we're going to move forward on this. Let's get you a hearing because we know this. Was anybody here last year? No? A couple of hands. Okay, last year at the GIL conference, the keynote speaker, I believe, was Jonathan Martinez, right? And he talked about supported decision-making. So his big case that's all over is Jenny. I can't remember her last name now, but Jenny. And she was an individual with Down syndrome, similar to Mike, put into the guardianship, and then he gets her out of the guardianship, restores all her rights. So Jonathan talked about supported decision-making, and so when I met Mike, I was like, oh, I'm going to use this. So we filed a petition to restore his rights, and what we did was we outlined what supported decision-making was. Because of we're the PNA, we do a lot of other things too, and we already knew that not a lot of people knew what supported decision-making was. So part of the petition is just outlining what supported decision-making is, and that's nothing more than saying I need help from other people, and I have people to give me that help. That's it. That's all it is. So in Mike's case, and yes, I can say his name because if he was here, he would be telling you his name, and he's on a podcast for us too. And there's a lot of lawyers who are like, oh, she's violating that. So we drafted a supported decision-making agreement, first of all, because we knew we were going to use that. But then we went through all the least restrictive alternatives, and we're like, well, right, you're lacking the capacity to manage your finances. The two questions for getting into a guardianship are not just whether or not you're incapacitated, it's whether or not there's any other least restrictive alternative, right? Well, durable power of attorney is a least restrictive alternative to managing your finances. So is rent payee. So we said, are you willing to do that? He said yes. I said, great, I'll draft a DPOA, we'll contact Social Security, we'll put it in the petition that you're gonna get a rent payee. We contacted a bunch of people, we found a rent payee, somebody who's willing to do it. He's in supported living. In this case, for APD, supported living coach can be your rent payee. It's an exception to the whole provider can't be the rent payee. So we had that done. And we filed a petition, and we said, you know, as far as his waiver services are concerned, everybody knows what person-centered planning is, right? That's basically supported decision-making. You get to be in control. Your waiver support coordinator, your providers are all there to help you choose what services you want. That's supported decision-making. So when it comes to healthcare decisions, he already has that in place by federal statute and federal regulations. All we added into it was a healthcare surrogate form, and he designated somebody for that. So in this case, the reason it works with Mike is because he had people there. He actually, and kudos to all of you, his former GAL had retired and was still involved in his life. And he said, yes, I'll be one of his supports. He had an uncle who lives in Texas who also agreed to be one of his supports. He had a friend that he met through one of the group homes and one of his ADT activities, and his mom agreed to be one of his supports. So those three people signed the supported decision-making agreement saying, yes, we'll be there to help him. And so with that, he got out of the guardianship. He is now working part-time at Target and selling ads for a magazine. He's involved in everything that he was involved in before that he hadn't been involved in for a year and a half, and he's happy.
Great, thank you. We wanted you to see there is other options. Thank you, Amanda. We have a bunch of questions, so we'll just start reading them and hopefully we can answer them. Can a relative of a ward take over as a plenary guardian if the bio parent's rights were terminated? Assuming that they're fit and qualified, absolutely yes. And we couldn't read the rest of that question. How does a guardian or guardian advocate prevent an undesired outcome such as murder? I guess you're referring to Regis, but we do the best we can. I don't have an answer for that. Neither does the panel. Go ahead, Wendy.
Okay, next question.
It doesn't work?
Hello. Oh, there we go. Okay. Currently, professional guardianships for the youth in need are pro bono. Are there steps being taken to create funding for Regis Little Law-created guardianships? No. That's the short answer. And the professional guardians take them pro bono, but in essence, they do, the attorneys that do the work for them still charge them a little bit of money. It's not 100% pro bono, but it's the best we've got going, and I'll take it. It would be a good thing for someone who is inclined for systemic change to start something. Next question, what is the step taken if a guardian dies while the need for guardianship still exists? It's called a successor guardian, and you must identify another person, whether it's another professional guardian, a relative that would qualify under 744, or the public guardian, and they get appointed. And if you can't get your the death certificate from the family, it's $5 in the mail from Vital Statistics. You need to file usually the original death certificate. So if you're helping that youth, that's what you're going to need. What type of, and the successor guardianship, you don't have the incapacity hearing. So it's very short, it's very easy. You just go to court one time to appoint another guardian. There's not the whole thing again. Okay, next question. What type of reports meet the statutory required assessments for Regis Little under Chapter 39? They must be, now I see, I kind of know where this question is coming from because you're like, we have so many things in the file. Can we just use something from the file? The problem is that they're usually old. And you must have one within the past 2 years, and you really need that educational, psychosocial, and the IQ component. And if they're have an autism thing, I need the spectrum. We had to kick one back, and it cost the CBO more money, but I needed to know where on the spectrum that the kid had autism. Is it mild, moderate, severe? I don't know. I need an IQ also to go with that. So they had to put out more money, and we should have that back any day now. It's long, it's very detailed, and it's thorough. It's by a psychologist, if not a psychiatrist, usually not a therapist or MSW, no. If anyone would like a redacted example of one, I can put that together. I think I've already done that. So you can email me, Wendy Robbins at DayLegalAid, wrobbins@daylegalaid.org. But you can, that's fine. Okay. Last question for me. Once the dependency court has made the determination that guardianship may be necessary, whose responsibility is it to file the initial petitions in the probate court? Well, it's nobody's real responsibility. It's not mandated by the statute. That's why the statute suggests help with pro bono attorney. It encourages pro bono involvement. So I would say contact your legal aid, your local legal aid, the pro bono portion of the legal aid if your legal aid doesn't do it, or somebody that you know, but it needs to be an attorney if it's going to be a guardianship. I'm going to hand it over. Next question.
Boy, we're talking fast. Does the procedure change if the youth is in DJJ custody until the 18th birthday? The only possible change is going to be having to figure out venue for where the guardianship should be filed. But when a child of ours, a dependent child, is in DJJ, DCF still has the legal custody of that child. DJJ has the physical custody. So if there is somebody who's going to be in a DJJ placement past the age of 18, and if, for example, they're on psychotropic medications and they would need consent from someone else if the youth is incapacitated, and not the incapacitated to stand trial kind of incapacitated, but rather the incapacity for a guardianship, then we still need to put a guardianship in place. As a quick aside, frequently, we have case management organizations that want to think that because a child is in some sort of a punishment system, whether it's DJJ or Department of Corrections, that they don't need to do any of the transition planning work, including the examination of possible guardianship, and that is simply not true. If DCF is the legal custodian, if there is a dependency case going on, then we still have to do all of the work because Chapter 39 doesn't say, except for those kids who are in DJJ. Next question, should the court extend jurisdiction to the age of 19 if guardianship is not yet in place? This is an excellent question and something that I'd never thought about, so I'm really glad you asked. And I think that the answer is yes. If you recall from 39 point, what is it, 013 or 0135, I don't remember, but now the court can extend jurisdiction to the 19th birthday for the purpose of ensuring that services that were ordered to be put into place before the 18th birthday are actually put into place. So that's an excellent thing to do. If we have a child who the judge says before the 18th birthday, you all go out and find a guardian for this kid, and we haven't been able to accomplish it yet. So then the judge can call you back in until the kid's 19th birthday to make sure that that's been done. Can a guardian make the decision for the youth to extend foster care? Yes, and I would say, well, actually, the extension of foster care, as I read it in Chapter 39, is that it's an opt-out statute, so that you're in unless you opt out. So if we have a child who's not capable, not capacitated to make that decision, and then they have a guardian or a guardian advocate, if this is one of the obligations or duties that they're given by the court, then yes, that guardian has the responsibility to opt their ward out if they think that that's important. Oh, and then here's the last one is for you.
If the youth is in DJJ out of county but intends to return or move to another county upon the 18th birthday, where's the venue? The venue is where the youth resides. I have gotten some referrals from the Panhandle because the case manager stays there, but the child lives in Miami. So that is where the guardianship or whatever must be filed, is where the child is living, the youth is living. Was that your question? You want to follow up?
No, I wanted to answer the first question, if I could.
Oh, about the youth in DJJ?
No, the youth who was, what can we do to stop the murder?
Oh, okay.
So to give some more background about Regis Little,
Why don't you come up here, Jerry?
I don't think anybody has difficulty hearing.
Yeah, but they're recording it, so, and then,
The answer,
yeah.
a little more background on Regis is that it was when he turned 18, he said goodbye to all of us because he made the decision to leave APD services, leave the foster care system services. So he, to the best of our knowledge, was taken advantage of. Oh, I'm sorry, for the recording. He was taken advantage of by some drug dealers who were using him, and that's how he died. If he had had a guardian, they would have been able to make a decision to help him in a supportive living environment, and he wouldn't have been on the streets where he was murdered. So that's the reason some of us advocated for the Regis Little Act that led to a mandate that we find guardians. No child should turn 18 without an adult helping them make decisions. Children with this level of disabilities especially need an adult to help them make sound decisions, or they will be at great risk. So.
Thank you.
Oh.
Last question?
Now I've forgotten it. Who finds the attorney for the guardian? For the guardian. So that's a good point. We've talked about it briefly up here. And the long and the short of it is there's nothing in the statute that says a word about how that's going to be found, how it's going to be funded. So what I would suggest is that if the guardian is the one that's really pushing the guardianship, who says, I'm going to go ahead and work and find the guardian, the potential guardian, then the GAL's attorney should probably assist with that. The Children's Legal Services attorney can assist with this. I will tell you, it most likely will not be the child's attorney. And the reason that it will not be the child's attorney is because the child's attorney, the AAL, is representing the child. There are very few kids who are going to say, oh yes, fine, take away all my rights. I want to have a guardian when I turn 18. It's a conflict of interest. It's an ethical problem. So where then do we go to find the attorney? Well, that's a good question. We, as has been said, hopefully, there will be relationships that are made in your circuits with your local legal aid offices, with your local bar associations. If all else fails, go to the judges and see if the judges can lean on people in the community that the judges know. Frequently, judges can have a good relationship. A lot of silk stocking law firms, they have good relationships with the judges. The judges can lean on other people to do it. And if an attorney says, well, I can't commit to doing this for 50 or 60 years, none of us can commit to doing anything for 50 or 60 years. To be honest, not a guardian, not an attorney. You can always move to withdraw at a later date if you need to get out of a case. So if a lawyer that you find says, oh, I would do it except I can't make the commitment, say, can you make a commitment to do it for 1 year at least? At least get us through the petition, get us through the adjudication of incapacity, get us through the appointment of guardian. And then if you find someone else to take over for you, you can get out.
Sure. Let me just add something really quick. Whoever files the petition for incapacity and petition for incapacity may not be the attorney that stays on the case forever. Because if you have a professional or the public guardian, they have their own team, they have their own team of attorneys that come in and they do the rest of it forever, for the life of the ward. But if you don't, and you have a person like a pro bono attorney, the only thing that I would caution is on that 1 year thing is that it's not as easy to withdraw in probate as it is to withdraw anywhere else. So maybe if that person finds that, an attorney finds that they can no longer do this, then maybe they can find someone else to come in. But just know it is really hard to get out of a case in probate. When it's the guardianship, sorry. Yes. Yes, however, if it's usually the public guardian, it's waived for legal aid clients, they're waived. It's an income-based requirement. It's like your poverty guidelines when you file for family or whatnot, it can be waived. It's not, if not, depending on your circuit, it's either a 1 case or a 2 case, and it's $400 and something right now per case. So, okay, thank you all very much. Oh.